Welcome back to another edition of Between Two FARS. I'm Warnike Miller, and I'm joined once again by the illustrious Judge Prouty. He is Vice Chairman at the Armed Services Board of Contract Appeals and has been really very generous with his time, helping us to understand operations at the ASBCA. We've started a series on attorney-client privilege and attorney work product and how that impacts us during discovery. Today, we would like to talk a little bit more about that in-camera process that we talked about earlier. If a judge does need to take a look at this stuff to determine, because the parties can't reach an agreement, determine is this admissible or not, what goes on? So can you talk us through a little bit about an average situation where you might have to do an in-camera determination and how that works and how you'd expect the parties to act, and maybe your thought process on dealing with an in-camera determination?
Sure. Basically, in-camera review happens when, for whatever reason, we can't determine whether or not the government is, or whichever party, it applies to the contract equally well as the government. We can't tell whether the government withholding documents has a legitimate basis based on privilege to do so. It's not enough for you to say, oh, this is privilege. There has to be a basis for us to find that. Now, sometimes a privilege log is detailed enough and clear enough that we can say, well, you know what, we don't need to do in-camera review because on its face, these documents are privileged. For example, if there is a document entitled Legal Review of Contracting Officer's Final Decision, and it was authored by an attorney, and it was provided to the client and those reasons, that would be a kind of document that on its face it may well be privileged, and there might be a good basis for holding it, and there might not be a whole lot of reason for me to have to look at it in camera. Because obviously, having to look at things in camera are suboptimal, because although we're a judge alone, and we can compartmentalize and try not to remember what we read, we don't want the fact finder to be looking at things that are potentially privileged, although sometimes we have to do that. If it turns out that we do have to look at something in camera, we try to limit which documents actually are the ones that need to be looked at in camera. And we look at it and we look at the expressed basis for the privilege and we see whether or not it's made out by the document. Now you can imagine that's pretty tedious work. And again, something we prefer not to have to do. So keep that in mind when you exercise your privilege. Also keep in mind, by the way, when you exercise your privilege, that if we look at something in camera and it is not well characterized in the privilege log, and you ask yourself, well, this does not seem to indicate a really good basis for privilege, and yet the government is asserting it, well, obviously that's going to color the way we look at other assertions of privilege from that attorney. And we might not be as willing to sort of swallow what's in the privilege log if we see that, well, they're having a very, very liberal view of how to apply this privilege. So keep that in mind. Sometimes it's better for you to allow some things in and to provide them that are harmless to you and are not privileged. Again, your decision of what is privileged and what is not privileged should not depend upon whether or not it hurts you or helps you. It's really based on whether the privilege actually should apply. But ask yourself, is this really privileged? And if it's not, don't fight it. It frankly also gives you credibility because it shows that, when we recognize something is not privileged, even though it's attorney, we're going to hand it over. And the cases where we're not handing it over are actually ones where the privilege really applies. Obviously, as you know, attorney-client privilege is a much stronger privilege than attorney work product privilege, which has its exceptions and is just sort of squishier. And it's very possible that different people looking at it might come to different conclusions about what really is covered by work product privilege. So again, that's a privilege that you should feel a little less confident in exercising, but that's the way it is. One last privilege that's not attorney-client, we'll get to in the next episode, which is about settlements.
All right. Well, let's just shift gears and try another hypothetical.
Okay.
We've got a witness on the stand, and they're starting to talk. And we know that the questioning on cross-examination is about to go into attorney-client privilege conversations. And we really don't want this attorney, we don't want this attorney asking these questions, and we don't want our witness starting to talk. how do we handle the situation? Do we ask for a sidebar? Do we make a standing table pounding objection? Do we wait until they've said something and then bring it up, or can we preemptively indicate that we're concerned this is where the testimony is going? I guess manners in front of the ASBCA. How do we handle this situation?
Sure. If you know there's going to be an issue early on, even before the hearing itself starts, there's going to be a pretrial conference. Every judges have different ways of doing things, but there's no judge who does not have a pretrial conference before the trial itself. It's usually a week or 2 weeks before the trial. And if you know it's going to happen, you can raise that issue at the pretrial conference. Oftentimes, in fact, different judges have different scheduling orders for leading up to trial. There might be space for a motion to eliminate. And if you know, you don't always know, but if you know that there's going to be attorney-client privilege issues raised, and you know this before a motion to eliminate is due, make it a motion about it. Because that way, it's a complicated matter, it's an important matter, and we can square it away early on. So that's the way to do it if you know it's coming. If you don't know it's coming, but by the time the person's testifying, you know that's going to be an issue, simply raise it with the judge. You'll have an opportunity. There's always, when a judge calls the case to order, there's always a chance to say, Judge, there's an issue I want to discuss, and you raise it, hopefully before testimony begins. Now, as you know, there's no sidebars at the board because it's judge alone. Now, however, so there's no jury to worry about hearing things. Now, there might be circumstances where you don't want the particular witness to hear about a document. It's hard to imagine those circumstances, but there might be a case where the circumstances are such that you don't want to discuss the matter in front of the witness. In that case, you can say, Judge, I would like to discuss this matter, but I'd like to have the witness excused, and you can explain why if you need to. In which case, you do. Like usually, there's nothing wrong with witness hearing it, and oftentimes they basically get to hear what you're not allowed to talk about, even though they already know about it. So you're not telling them anything they already know, but you're letting them know, okay, you don't get to talk about this issue. So that's how you do it. And that's pretty much it.
No, that's very helpful and a good practice tip. Thank you. As we alluded to, there's more when it comes to privilege and discovery and hearings. So I hope you'll come back again while we wrap up this little mini segment on privilege and join us for one more episode of Between Two FARS.